Available now. Link below.
Tonight we're diving into a battle that strikes at the very heart of our republic. Imagine the world where your voice, your opinions are suddenly silenced. Not by the government, by the new gatekeepers of public discourse, big tech. Now this isn't fiction, it's happening right now. The Supreme Court's decision to review laws from Florida and Texas represent a turning point. Now these aren't just legal battles, they are a fight for our fundamental freedoms. So what's at stake? Well, the very essence of free speech in our digital age. And if you value your right to speak freely online, this is one report you can't afford to miss. So stay with us, because by the end of this report, you'll understand not just the implications of these cases, but why this fight is crucial for every American. And believe me, you don't want to miss my final thought on this. It's a perspective that could change the way that you see the digital world. Now, before we dive deeper into our crucial discussion today, I've got something important to share, closely tied to what we're talking about. Imagine in a world where your voice can be easily silenced, there is a beacon of hope that keeps you warm in the chilling silence. That beacon, a portable heater standing up against the cold front of high utility bills, a symbol of fighting back against the overwhelming power of monopolies. Just like we're advocating for free speech against big tech's chilling effect, this heater pushes back against the grip of high energy costs. Thousands have already bought warmth to their homes with it, slashing their energy bills by 30%. So join the resistance against being left out in the cold. Secure yours now at 55% off and feel the warmth of freedom. Visit getwarmnow.com, and remember, it's not just about staying warm, it's about making a stand. Now, in the heart of America's ongoing battle for free speech, a seismic shift is underway, challenging the unchecked power of big tech. The recent decision by the Supreme Court to review controversial laws from Florida and Texas marks a pivotal moment in our nation's history, one that could redefine the boundaries of online expression and censorship. Now, these laws, born from a growing concern over the silencing of conservative voices, seeks to ensure a fair and open digital public square for all. Florida and Texas have taken bold steps against the perceived bias of social media giants, implementing legislation that prohibits the deplatforming of political figures and demands transparency in content moderation practices. Now, this move not only challenges the status quo, but also ignites a crucial debate on the balance between private enterprise and public discourse in the digital age. As we stand on the brink of potentially groundbreaking legal precedents, the implications for free speech and the future of digital communication are profound. Take a look.
These were passed after the 2020 election, when many social media companies were worried about misinformation and the election, but others criticized those companies for censoring conservative voices. Now, lawmakers here in Florida and in Texas passed the bills in 2021. They were responding to moves by some of the social media platforms, especially Facebook and Twitter. Those moves included banning some very prominent people like former President Donald Trump. The laws are designed to protect those kinds of users from being censored, but the tech companies argue the laws violate their free speech rights to moderate content that could be considered hate speech or harassment. Today, the states and the companies will have their chance to argue their cases in front of the U.S. Supreme Court, and the justices will have to weigh the First Amendment claims of each side.
We're more of a free speech absolutist country, and so that's going to limit what the government can do to regulate the content.
The law in our state would let the Elections Commission fine the social media companies $250,000 a day for deplatforming statewide candidates, and those candidates could sue for damages, but federal courts have blocked those laws from going into effect up to this point. Those oral arguments in front of the U.S. Supreme Court start this morning at 10 a.m.
Now, critics argue that these laws infringe on the First Amendment rights of private companies, a perspective that underscores the complex interplay between freedom of expression and the role of digital platforms as arbiters of public discourse. However, proponents, including myself, view these legislative efforts as essential safeguards against the monopolistic tendencies of big tech, which wield unprecedented influence over the global exchange of ideas. Now, the core issue at hand transcends partisan lines, touching on the fundamental right to free speech enshrined in our Constitution. Amid debates on big tech's influence in free speech, a crucial exchange between Justice Alito and Paul Clement questions if content moderation is in fact censorship. Now, this dialogue highlights the broader concerns over digital platforms' control, essential for understanding the free speech versus regulation debate. Take a look.
There's a lot of new terminology bouncing around in these cases, and just out of curiosity, and one of them is content moderation. Could you define that for me?
So, look, content moderation to me is just editorial discretion. It's a way to take all of the content that is potentially posted on the site, exercise editorial discretion in order to make it less offensive to users and advertisers.
Is it anything more than a euphemism for censorship?
Great question. Now, the Florida and Texas laws represent more than just regional pushback against Silicon Valley. They symbolize a national awakening to the dangers of digital oligarchies. These platforms, which once promised open forums for debate and discussion, now stand accused of selectively muting voices that diverge from certain ideological conformity. The legislation challenges this status quo by demanding accountability and fairness, principles that are cornerstones to our republic. Now, this isn't merely about protecting conservative viewpoints, it's about preserving the democratic principle that allows for a diversity of opinions without fear of retribution or censorship. The argument posited by social media companies that their moderation decisions are merely exercises of editorial discretion fails to acknowledge the unparalleled power these platforms have in shaping public opinion and discourse. Unlike traditional media outlets, social media giants control access to the digital public square, where the lines between private and public speech blur. Now, the legal battles over these laws bring to light the urgent need for a recalibration of our understanding of free speech in the age of the internet. Should the Supreme Court side with Florida and Texas, it would not only curb the overreach of big tech, but also reaffirm the government's role in protecting citizens' rights against the encroachment of private entities with quasi-monopolistic control over public discourse. Now, at the heart of this debate is the recognition that social media platforms, by virtue of their size and influence, have evolved into more than mere private enterprises. They are the new public squares, and just as the government has a duty to protect free speech within traditional public spaces, so too must it ensure that digital forums remain open and equitable for all, regardless of political persuasion. Now, the contention that these laws infringe on the rights of social media companies overlooks a crucial fact. With great power comes great responsibility. If these platforms wish to continue enjoying the protections afforded by Section 230 of the Communications Decency Act, which shields them from liability for user-generated content, then they must also shoulder responsibility of ensuring their moderation practices do not discriminate against lawful speech. So as we move forward, the Supreme Court's decision will undoubtedly have far-reaching implications for the future of online expression. But beyond the legal arguments and judicial outcomes lies a larger truth. The fight for free speech is not just about the ability to speak, but about ensuring that every voice, no matter how divergent or unpopular, can be heard. So this is more than a legal battle. It is a cultural war over the soul of the internet. A victory for Florida and Texas would send a clear message. America will not stand idly by as a handful of tech moguls dictate the terms of national discourse. It's a reaffirmation of the principle that in a republic the power of speech must lie with the people, not the gatekeepers of the digital age. And if it does in fact go forward, this is probably one of the messages you might find on one of our videos in the near future. Now, if you got value from this report, tap subscribe. My final thought is next. As we navigate the complexities of this digital era, the struggle between big tech censorship and the preservation of free speech emerges not just as a legal battle, but as a fundamental test of our democratic values. The actions of Florida and Texas underscore a critical question. Will we allow the guardians of the digital gateways to dictate the terms of our public discourse, or will we demand a digital public square where freedom of expression is protected for everyone? This is more than a fight for the right to speak. It's a fight to ensure our voices, in all their diversity, are not silenced by the few who control the platforms where our modern dialogues unfold. Let's champion a future where free speech remains free, unencumbered by the whims of digital overlords.
Congratulations, you made it to the end of the video. Now keep up your quest for truth with this next news report. And if you found our channel enlightening, join the millions who agree with you. Tap subscribe. Thank you for watching the Next News Network.